The jury stands as a cornerstone of the United States adversarial legal system, serving as the ultimate fact finder. For bar exam purposes, understanding the jury trial involves mastering two distinct, yet interconnected, areas. First, we must establish the constitutional foundation. When exactly is a jury trial guaranteed? This requires distinguishing between criminal prosecutions, governed primarily by the Sixth Amendment, and civil suits, governed by the Seventh Amendment. Second, once the right is established, we must examine the practical mechanics of seating that impartial panel. This selection process is formally known as voir dire, which translates to speaking the truth. This chapter sets the stage by introducing these two critical components: the constitutional right to a jury, and the procedural steps taken to seat one fairly. We will explore the text that grants this right, and then transition into the courtroom procedure designed to uphold it. We now delve into the specific constitutional text guaranteeing the jury trial. In criminal prosecutions, the Sixth Amendment secures this right, ensuring an impartial jury is present. For civil matters, the Seventh Amendment preserves the right in suits at common law provided the value in controversy exceeds $20. While that monetary threshold is largely historical, the distinction between legal and equitable claims is crucial for bar exam analysis. Regarding applicability, both amendments apply directly to federal courts. However, the Sixth Amendment right in criminal cases has been incorporated against the states via the 14th Amendment's Due Process Clause. Interestingly, the Seventh Amendment right in civil cases has generally not been incorporated, meaning state civil juries are governed by state constitutions, not the Seventh Amendment directly. Now that we understand the Sixth Amendment right is incorporated against the states for criminal trials, we must examine its precise scope. This right is not absolute. It only attaches to what the Supreme Court defines as serious offenses. The critical metric here is the potential penalty imposed upon conviction. If the crime carries a potential term of imprisonment exceeding 6 months, the defendant generally possesses a constitutional right to a jury trial. Offenses carrying 6 months or less are typically classified as petty offenses, where a jury is not constitutionally mandated. Furthermore, we must address the verdict itself. In federal criminal trials, the jury verdict must be unanimous to convict. Crucially, the Supreme Court has ruled that this requirement for unanimity also applies to state felony convictions, ensuring consistency in serious criminal adjudications across the nation. Having established the Sixth Amendment's reach in criminal matters, we now pivot to civil litigation and the Seventh Amendment. This amendment preserves the right to a jury trial in suits at common law, where the value in controversy exceeds $20. Unlike the Sixth Amendment, the Seventh Amendment has not been fully incorporated against the states for all civil proceedings, though many states provide similar rights by statute or constitution. The crucial determination for applicability rests on a historical test: is the claim fundamentally legal or fundamentally equitable? Legal claims, historically tried by juries, mandate a jury today. Equitable claims, such as injunctions or specific performance, remain the province of the judge. Modern analysis, complicated by the merger of law and equity courts, requires looking at two factors: first, the nature of the remedy sought, and second, how the claim would have been treated in England in 1789, when the amendment was adopted. This historical lens guides whether the Seventh Amendment right attaches. We have thoroughly examined the constitutional foundations that grant the right to a jury trial in both criminal and civil cases. Now, we transition from defining when a jury is required to the practical process of seating that jury. This critical procedural step is known as voir dire. Literally translated from French, voir dire means to speak the truth. This process is the mechanism courts employ to fulfill the constitutional mandate for an impartial tribunal. The primary objective during voir dire is rigorous questioning designed to identify and remove any potential jurors who harbor biases, preconceived notions, or conflicts of interest that would prevent them from being fair and impartial. While the ultimate goal is to seat a jury that reflects the community, this selection must always adhere strictly to established legal standards of qualification and fairness. Having established the purpose of voir dire, to secure truthfulness and impartiality, we now examine the practical execution of this selection process. The pool of potential jurors summoned to court is formally known as the venire. The questioning of the venire is typically a collaborative effort. Initially, the judge often conducts broad, general questioning aimed at identifying obvious conflicts or basic qualifications. Following the judge's lead, the attorneys for both sides then take over for more targeted, in-depth follow-up questioning. The core objective remains consistent throughout, to probe deeply into the backgrounds, beliefs, and relationships of each potential juror. This rigorous examination seeks to uncover any hidden biases, preconceived notions, or specific conflicts of interest. The ultimate aim is to ensure that every seated juror can commit to rendering a verdict based strictly and solely upon the evidence presented during the trial, and nothing else. Now that we understand the goal of probing for bias during voir dire, we turn to the primary tool attorneys use to remove unsuitable candidates: the challenge for cause. A challenge for cause is a formal request to the court to dismiss a prospective juror based on a specific, articulable reason demonstrating that the individual cannot be impartial. These reasons must show an actual inability to follow the law or weigh the evidence fairly. Common examples include a close personal relationship with one of the parties or attorneys, or the expression of a strong, unshakable bias regarding the subject matter of the case. The critical feature distinguishing this challenge is its quantity. Challenges for cause are unlimited in number. However, this unlimited nature is balanced by judicial oversight. For every such challenge asserted, the attorney must convince the judge that the stated grounds are indeed valid and sufficient to legally disqualify that specific juror from serving. While challenges for cause address demonstrable bias, the second method attorneys use to shape the jury is the peremptory challenge. Unlike challenges for cause, a peremptory strike allows an attorney to dismiss a prospective juror without needing to state any specific reason to the judge. This tool is invaluable for removing jurors where the attorney suspects bias but cannot articulate grounds sufficient to meet the legal standard for a challenge for cause. However, there is a crucial limitation on this power. Peremptory challenges are not unlimited. They are restricted to a small, predetermined number set by statute or court rule. More importantly, the Supreme Court has imposed a fundamental constitutional restriction. Peremptory strikes cannot be exercised for the sole purpose of excluding jurors based upon their race or gender. Even though no reason is required for the strike, the underlying motivation cannot violate the Equal Protection Clause. We will explore how this prohibition is enforced in the next segment. Since the Equal Protection Clause prohibits striking jurors based on race or gender, the Supreme Court established a specific mechanism to police this constitutional boundary during jury selection. The Batson Challenge? This challenge is crucial and follows a mandatory, three-step framework that shifts the burden of production between the parties. First, Step 1 requires the objecting party, the party claiming discrimination, to make a prima facie showing that the peremptory strike was motivated by race or gender. This initial hurdle is relatively low. Second, if the objecting party meets this initial burden, the burden shifts to the striking party. They must then articulate a clear, race-neutral, or gender-neutral explanation for striking that specific juror. The explanation does not need to be persuasive, only neutral. Finally, step 3 requires the judge to evaluate the proffered explanation. The judge must determine whether the explanation is genuine or merely a pretext for purposeful discrimination. This ultimate finding of pretext or lack thereof is a factual determination reviewed on appeal for clear error. Mastering this three-step process is essential for the bar examination. We have now covered the entire spectrum of jury trials, from the constitutional right to the final selection process. For the bar exam, remember these core concepts. First, the right to a jury is triggered constitutionally by the Sixth Amendment for serious criminal cases, and by the Seventh Amendment for civil suits at common law exceeding $20. Second, understand the tools for seating the jury. Challenges for cause are unlimited, but require a demonstrable showing of bias. In contrast, peremptory challenges are limited in number and cannot be used discriminatorily. Crucially, every strike, every decision made during jury selection, must adhere to the fundamental requirement of fairness. This fairness standard is actively policed by the Batson Doctrine, which prevents the use of peremptory strikes based on race or gender. Keep these foundational rights, the distinction between the two challenge types, and the Batson safeguard clearly in mind for exam success.